patriotism and passion for the country is exercised in your showing up.
Thank you very much for your kind words, Zach. I really find myself honored to always appear on your radio station, even at shortest notice. Except today, I think we had some complications to try and get into town because of the road congestions. But I sincerely apologize for that. But I'm grateful that I'm here and we can cover some ground. Yes, on some of these issues that are very important.
I think that Bill 7 has finally passed, obviously waiting for accession by the president into law.
Yes.
But
really, today, like somebody said, or yesterday rather, marked a very dark day for constitutional democracy in our country. But also it brought to an end one of the most controversial journeys that we've ever walked in the shortest possible time in our attempt to effect amendments to the Constitution in the manner that is probably the most controversial since the time that we earned our independence. I think there's everything that can be said about this journey that we've taken from the day that the UPND started the process of trying to amend the Constitution and all the layered controversies that we went through, which pointed out to the very fact that we're actually going in the wrong direction. So what you now have is a scenario where we've ended the journey where the people who are governing you are dragging you in one direction, and you as a nation are trying to pull them back in another direction. But unfortunately, using the arrogance of numbers and unfortunately using the fear that was brought to bear by the political elites on some of the people that were mandated constitutionally to come and protect the Constitution, we've ended the journey on a very, very unfortunate state. We have actually transformed this country with just one stroke of a pen, one vote in Parliament on a day. Second reading, third reading proceeded, and the amendment passed. It now remains to be seen what kind of country we are going to have for the next foreseeable future. And definitely, like I said before, chickens always come home to roost. We have not succeeded in anything by passing Bill number 7. We have violated the Constitution. We have dampened the morale of the voters on the streets. We have, disobeyed kind counsel that was given to the politicians by the church, by credible CSOs, even by the diplomatic corps. This is a mark of a greatest level of stubbornness by a small group of people trying to impose themselves on the larger majority, contrary to the principles of democracy and contrary to the Constitution as we know it.
And I think what has been the bone of contention is the fact that most of the CSOs, like you mentioned, the church, were singing a song of an unconstitutional process.
Yes.
Where is it unconstitutional?
There were 2 points that came to light in the engagement. Firstly, the timing itself was very wrong. We've had very important amendments effected to the Constitution within a period of 7 months. It has never been heard of, not anywhere else. The other day I classified this process as making a constitution through a microwave process rather than getting a constitution that emerges from wider stakeholder consultation. So the timing was wrong. Secondly, the roadmap that was followed by the UPND in trying to amend the Constitution was itself wrong and also a violation of the Constitution and the principles of constitutionalism. This is what came to light when this process was first challenged. Zach, our Constitution is very clear on how you can go about amending it. At every level of attempting to amend the Constitution, the biggest demonstration you have to ensure takes place is one where you show that all stakeholders that are concerned with what you want to achieve in the constitutional amendment process are given the opportunity to participate in that process. But most importantly, constitution making is actually owned by the people and not by the politician. For many times I've been arguing that the only thing politicians add to the constitution making process is this fire code or this fuel called political will. Because, you see, they are elected, given the rare mandate to be the ones that provide political will, but also ultimately the ones who go and sit in the chamber, in the House, to actually amend the Constitution based on what the stakeholders would have said and put in the constitutional process. So what had happened is that the UPND, for reasons that up to now have remained very obscure, decided to start a process of amending the Constitution in March this year, to walk us to a place where until when we get to close Parliament in May next year, would have done the whole process of amending the Constitution. People raised concern about that. In Parliament, we told them this is not correct. Even the manner in which they were bringing it to the Parliament was incorrect. A Constitution is respected most importantly, by the process which you implement, okay, and by the legislative regime that you create to protect the process itself. So the process and the protection of measures that you take in protecting the process are as important as the content of the Constitution is. If you saw, the UPND quickly rushed the citizens to ask them to begin to speak to what is contained in the Constitution. When the stakeholders raised the issue with the process that was espoused by the UPND in trying to amend this Constitution, this issue went all the way up to the Constitutional Court.
Right.
You know, at the quest of Murinia Zulu and Celestine Mkandila, who sued the Attorney General. And the Constitutional Court, under our current constitutional setting, in Article 128, is the apex court in determining what is constitutional or what is not constitutional.
Right.
So we all have agreed by enacting Act Number 2 of 2016 that when we have a dispute or a misunderstanding about whether what we are doing or what we are about to do is constitutional or not, all of us have surrendered our powers to those women and women who sit in the Constitutional Court to make a determination that are doing is either constitutional or it is not constitutional. And that agreement extends to the fact that if they say what you're doing is unconstitutional, it binds everybody. It binds me at that parliament. It binds His Excellency the President at State House. It binds you, sir, as a citizen of this republic. Because this is the agreement that we had, and it is contained in Article 128 of the Constitution. So when this matter was taken up to court, the court deliberated on it and made a determination. Okay, they did two things. Firstly, they nullified the process, okay, by which UPND had attempted to introduce amendment to the Constitution. They declared it null and void. Now, under the law, when something has been declared null and void, you're actually saying it doesn't exist. Okay, whatever you're doing is a non-existent process. So they declared it null and void. Secondly, they guided UPND and said, look, we would like you to go and start this process afresh. You know, go and make sure that it complies with these guidelines. And they actually gave guidelines.
That's right.
Firstly, it's supposed to be through an objective process. People who are appointed to a committee are supposed to be objectively and openly appointed. Okay, so there's no subjectivism in that. And secondly, that committee is supposed to engage in what is called wider stakeholder consultation. And that is what the Constitution actually demands, because then you are responding to what are called the principles and values that are espoused in the current constitutional setting that we have. Okay, if you remember.
So the null and void. Let me get you right. The null and void was not on Bill 7. Was on the process, and there is a debate now where people are saying Bill 7 is illegal according to the Constitutional Court.
Yes.
And I keep arguing to say the Constitutional Court did not say that Bill 7 was illegal, but the process, and they guided on how the process should be conducted.
Remember the point that I gave you at the beginning? When you are making a constitution, you need to create it at the backdrop of safeguards. And safeguards basically espouse the process itself that gives birth to the bill itself. Okay? And the court guided. And you know, you can't you can't divorce one from the other. When the court says the process that has given birth to the bill is itself null and void, the bill can't exist, you know, as a non-nullity independent of the process that brought it into life. The law is logic. Okay, that's why we use terms like syllogism. There must be a logical connection between what you are starting and what you're going to end up with. So when the court said this process that you guys are putting in place, you know, to try and bring about this Bill 7 is itself a nullity because it doesn't comply with the Constitution. That simply means even Bill 7 itself was a bastard, for lack of a better term. It was an illegitimate child that was born from a process that was condemned by the court that you're appointed to make decisions whether or not what you're doing is unconstitutional. And quite frankly, for me, the court then gave them, the court was fair to them. The court then said, look, go and start a fresh process. Okay? Now, in logic, what that meant was you have to completely abandon this Bill 7, come back again and comply with the preconditions for creating a bill. And the preconditions for creating a bill is wider stakeholder consultation. And the UPND, in the early days after the decision of the Constitutional Court, did not even attempt to appoint a technical committee. If you saw the reaction, let me just explain so that people can understand what transpired. when that matter was challenged in court, the court heard arguments and gave a date when they were going to make a determination. Somewhere in my intuition as a lawyer, that information, slipped through and reached the president that this process that you had initiated, and by that time the bill was already on the floor of the House.
Yes, that's right.
So this process by which this bill, which is on the floor of the House, was initiated, is going to be condemned in court. Okay, so what we had in Parliament was first we had an amendment to the order paper of that day. They introduced the business for the Minister of Justice to come and address the Assembly.
Right.
And the Minister of Justice came and addressed an Assembly. In fact, at that day, we woke up to the screaming headlines of the news, because UPND is a very good institution of propaganda. We woke up to screaming titles in the newspapers that the Republican President has guided the Minister of Justice to go and defer Bill 7 in the House. Okay? And for us, we were astounded. We wake up, the order papers change, the minister comes in and suggests to us that this bill is being deferred. It was, I think, a Friday, if I'm not mistaken.
Right.
The following day on a Monday, the Constitutional Court anyway went ahead and delivered its judgment condemning the bill. So now we're at a scenario where the bill is on the floor of the House. The process by which the bill was originated and brought to the floor of the House has been condemned and declared null and void by the Constitutional Court. So the question that now arose at that time was, what are the next steps that we're going to take? For us to understand both parliamentary procedure and constitutional law, we were confident that the state is going to start the process all over again, and we're going to have another bill in replacement of Bill 7. Now, the requirements on any new bill was you would have to publish it and then gazette it. Okay, now that was going to, according to them, eat into their term coming this way. So originally they didn't want to appoint a technical committee. On the floor of the House, a member of Parliament for the UPND raised a point of order to ask the Speaker to state to us what was the state of Bill 7, given the fact that the Constitutional Court had condemned it.
Yeah.
The Speaker, it cleverly made a statement that insofar as we are concerned, this is Parliament. That is the Constitutional Court. Whatever they're doing there is their baby. What we're doing here is our baby. As I'm concerned, the minister will be at liberty to bring back this bill, because what I have on the record is that this bill was deferred. Now, for me, that suggests connivance, that the reason to have it deferred was possible agreement, between the legislature and the executive. Okay, instead of withdrawing the bill, they deferred it. So they kept it alive, and for a reason. Okay, and you need to follow me very, very. So they kept that bill alive for a reason, knowing that people are now going to raise fundamental issues about whether we are listening to the Constitutional Court and the guidance that they gave. And in the disquiet that we heard, one time we were just told, our bill is coming back to Parliament. And some of us said, but we've read the judgment. We can't bring that bill to Parliament without complying with the conditions that the judgment actually set. So in that very time, I think on a Wednesday, there was a pastoral letter that was bishops, the ZCCB, Zambia Catholic bishops, and they said it would be unfair for this government to proceed with Bill 7 for two reasons. Firstly, secondly, we're heading towards election, and they didn't even comply with the conditions that the guidance the court had given them. About that very time, the president surprisingly appointed a technical committee. Okay, now, in semblance of compliance with the guidance, the court's guidance.
Yeah.
Okay, that's when we heard this announcement or the technical committee. People rose again, condemned, but you can't do this, and the others were saying, no, these are cadres have appointed, etc., etc. And the appointment itself was also mad in controversy, because first the president appointed this technical committee without terms of reference. Okay, and people raised issues with that. Then there was a swearing in of these individuals without terms of reference. Okay, and people now made louder noise. No, but this is not fair. You can't do this. You can't employ somebody, have him confirmed on a job without giving him his job description. In the evening, I think the Secretary to Cabinet on that very day, about 20 hours, that's when I saw what was now published as terms of reference. Now, if you saw what happened, the terms of reference were a duplication of what was contained in Bill 7.
That's right.
Okay, and people then said, oh, now we understand this how devious the UPND is. In fact, Laura Mitty wrote a scathing attack on the UPND, saying this is the most deceptive government ever to have managed the affairs of this nation. Because what I've seen as terms of reference and what is contained in Bill 7, which was condemned by the Constitutional Court, are basically one and the same thing. Okay, anyway, we went ahead. Okay, the committee, went around, and you see, when the court says wider stakeholder consultation, they mean it. They mean that people that are, concerned with constitutional matters are given an adequate opportunity to come and appear before whatever committee are going to put in place and do whatever they need to do to make sure this process has stakeholder consultation. But you saw how the technical committee worked. They went to one district in every province, spent not more than 3 hours at every engagement. And you call that wider stakeholder consultation. They came and sat here. And when people started condemning them, said you can't have a technical committee. His views from UPND cadres and you compromise, CSOs, etc. They said, no, we have, according to them, they said they were overwhelming. The submissions were overwhelming. And they prepared a report anyway, which I think is about 500 or 500 pages. I don't know, because I haven't gone through the whole report because of this controversy. They prepared a report and they responded to the terms of reference that were given to them, the most important of which were that they should do a report and they should draft a bill. Now, you then connect it with the Constitutional Court. The Constitutional Court condemned Bill 7. That's why the terms of reference for the technical committee included, among other things, the duty or the quest for them to draft a bill. And these guys drafted a bill and they handed over to the Republican president. In fact, it was handed over by Landlani Banda, who was the vice chairperson of the committee, because I think the chair was incapacitated. Okay? And the people are now anxious to hear what is in the report, what is in the draft. That very night, we were dated by my younger brother, Cornelius Mwito, the Minister of Information, saying the government has rejected the submission of the technical committee. Now, the Concord has condemned the bill. The Concord has guided you to come up with a technical committee so that it can author a report. These conditions you pretend or you window dress to the Zambian public that you are complying with it, and therefore the technical committee is in place. They give you a report and you come to the public and say, we are not going to do it. We are going to still go ahead with the
bill on the floor.
Now, Bill 7, it means you are now walking into a state of contempt of court, because the court condemned that bill and nullified it. Okay, but then they went ahead. Unfortunately, when the Munia Zulu and others decided, no, but this is contempt, we're taking it back to court, the court seems to have vacillated. It never actually came to assert its position on whether going ahead with Bill 7 is contempt or it is not. But you see, for us, this is when now we interrogated our responsibilities as members of parliament for the Patriotic Front and some very credible independent members of parliament, and also the NGOs now started putting pressure and demand on the members of parliament. What are you going to do, in furtherance of this nefarious and unconstitutional scheme of still implementing Bill 7 when the court condemned it? We canvassed, we spoke to each other, to some of us who are seniors and who understand constitutional law and parliamentary matters, we spoke to our colleagues, gentlemen, we can't deal with this matter. And everybody seemed at that time agreed. If you remember, there was even a signature that was passed around that these MPs have agreed they are not going to vote for Bill 7. I'll tell you the truth, some of those who have voted, I don't have a list yet to compare, because surprisingly, Parliament is not releasing the list. It is supposed to be produced almost immediately after you finish voting. But this voting that took place yesterday, nobody has details of who voted and who didn't vote. So everything has gone into a level of...
So what's going on social media in terms of the list is not...
speculation, but it's also consistent because of what I'm going to explain happened, in terms of who left and who went where.
That's
and how
right.
they came to Parliament.
Yeah.
So it's consistent because there's visibility of the names that are there and what actually transpired a day and 2 days and a day before they went into the house to go and vote. So for us, out of the canvassing and engaging with other stakeholders, especially credible CSOs and even the church, we then made a resolution as opposition members of parliament, that we're not going to do it. And I can tell you that at my personal level, I had made that decision a long time ago. Why? Because firstly, I went to Kasama and explained to the people in the constituency, this is what we are going through, and got feedback from those who are credible and those who understand how Parliament operates.
Yeah.
So I told them, I need to hear you out. Can we continue participating in this process? And the answer they gave me was the resounding no. You can't give credibility to a process that has been condemned by the Constitutional Court. But even at the level of a lawyer who has practiced law in this country, who knows how laws are formulated, and who knows what the fate of a document that is declared a nullity, is supposed to be. I then told myself, I now found myself clashing on the two oaths I've taken. In fact, my oaths are so many, because when I was called to the bar back in 1993, I took an oath on the Constitution. Yeah. And even at that time, I remember I also took an oath, an oath allegiance to the president. At that time, it was Freddie Chiruwa was the president.
That's right.
Okay, so you get yourself in a scenario where you have a clash of two oaths, and which is why in 1998 or 99 thereabout, I deliberately and voluntarily enlisted on the Oasis Forum. Okay, because I discovered that I had a where my oaths were clashing. I have sworn to uphold and protect the Constitution in one oath. I have sworn an oath of allegiance to the office of a president in the other. And these two oaths are now competing. Which oath am I going, to comply with? Now, if you are a student of constitutional law and even jurisprudence, one thing becomes alive immediately applied to you. A constitution is just but a piece of document. The life that we give to the Constitution is what we do ourselves. Human vigilance is what gives life to a Constitution. So, and then you have an allegiance to an oath of a president. The president is a speaking person. He can talk to you. You can even differ in opinion. Okay? So if you know that the president has done something that is wrong, do you still want to be bound by the oath that you gave to respect him, to give him allegiance, even when he's violating the Constitution? So at that time, I voluntarily registered or enlisted myself on the Oasis Forum and became one of the consultants ran all over the country against Chiruwa's third-term bid, because that was unconstitutional. Okay? Even this time, I now at a personal level as a legislator, as a lawyer, as a member of parliament from Lukashya constituency, I ask myself, so which of these two oaths am I going to protect and uphold? Because if I'm going to uphold the oath of allegiance to President Ndagande Ichilema, I'll be breaching the Constitution. In fact, I'll be joining him in the bid of breaching the Constitution, because I am very convinced myself that from day one, what the UPND has been doing with Bill 7 is unconstitutional. But for me, it's even worse, because several other events that the UPND has subjected the country to have been unconstitutional. We have argued about the appointment of the second deputy speaker at Parliament. It doesn't comply with the Constitution. We have argued about the transactions for KCM and Mopani. They don't comply with the Constitution. We have argued about the Ndola Lusaka dual carriageway. They didn't comply with the Constitution, because there's an article in the Constitution that demands that the executive must bring those cases to the House, and the House must ratify those transactions. But see, they colored these transactions, the window dresses transactions to make them look like these are just business transactions that don't need, parliamentary ratification. But all those for me are chronicles of how the UPND does not respect and comply with the Constitution. So at this time, I took a vote myself. I said, I am going to uphold the Constitution, and therefore, I am not going to participate in an unconstitutional process of attempting to amend this Constitution, because I've condemned Bill 7 from day one anyway. But several other of my friends actually took the same thought process. The challenge that I think we are being asked to answer now as members of Parliament of the Patriotic Front is, how come your colleagues went ahead and voted?
That's right.
It's an elephant in the room right now. But
obviously, we'll have to deal with that as a party.
We're actually dealing with it. If you heard the president, I think was the acting president was on TV yesterday saying we will interrogate this, will come to the fact. But see, I can address it very briefly from my perspective.
That's right.
One thing that should never escape those who are scrutinizing what transpired is to ask themselves a question. Okay, we know what happened. You see, our colleagues were taken away. Okay, they were confined somewhere, for some time. And those who
is that a fact?
You saw how they came to Parliament. First, they went missing for 48 or 24 hours.
And you there as your members?
Well, the leaders kept asking questions. We got leaders. They kept asking questions, and the answers they were varying. But most of them were consistent that they were not going to be in the House to vote. And what was a bit common among the answers that we're receiving was that these guys have gone back to their constituencies because apparently, if you know, Parliament should have closed on. So everybody was thinking, well, they have gone back home. They literally spoke to our leaders saying, no, and the constituency, I'm going to some other business. I'm not going to be in the House. But later information sifted to us, that these people have been confined somewhere, by the leadership of the UPND, and they were being given certain assurances. I wouldn't want to go into conjecture or speculation because I need evidence. But quite frankly, the very fact that they were removed from public circulation is very, very clear. Okay, and if you saw what then happened on Monday, Parliament was even playing a game with the public. Because the first time you saw Parliament when it opened somewhere around 9 hours, the bench for the opposition backbenchers was empty. There were only about 2 people there. And some of the people even went to social media, Bill 7 has fallen, Muribe, my MP, Svali Mamuja. Okay, and then someone said, wait a minute, they will come. So there was other business that was being conducted before they went to Bill 7. But shortly before they went to Bill 7, you saw vehicles being driven into the Parliament grounds. Each member of Parliament has got his own vehicle. We all drive ourselves to Parliament. But this time they were being driven, in a smaller number of vehicles. And I think there were, what you saw on social media, there was even a bus. So they were now picked from wherever they had been confined, and then brought in. And if you saw what they did, they just went in there and sat. None of them debated. None of them gave the nation the reason why they are agreeing with Bill 7. They just sat there and waited for the time to vote. If you saw what my younger brother Chisanga, of course, he waffled around, when he was given an opportunity. And you can see, this is what we've been saying, Zach, every time we come to TV. That Zambians must take an interest in what is happening to the nation. Can you imagine how we have amended this constitution this time around? First, we destroy the real opposition. Okay? Cause Brian Munduwe to be removed in a manner that you create a suggested blame for the Patriotic Front. When everybody knows what is happening, when everybody knows what kind of relationship the Chisanga has with the Republican president, we have raised these voices all over we are actually raised alarm. Okay, and now what you are seeing is a culmination of what we told you before, that we are destroying democracy. We are destroying the rule of law. We are destroying constitutionalism. But most importantly, we have destroyed Parliament. Because Chisanga does not command any respect of the genuine members of Parliament. Even those who went to vote with him this time, they voted for him for reasons other than the reason that they could respect Chisanga as leader of opposition. But you saw what then happened. He was the one who was even given the podium. Oh, yeah, leader of opposition. And the young man stands up and makes exclamations that are not making sense. Puts in invectives against some of us who are not even in the house, literally painting a cozy picture of how it is appearing that we have all agreed to amend this. And then he sits quiet, a few arguments here and there. Young Kangombe put up a fight, a lone ranger, as it were, to try and see, how he could put in those amendments to the Constitution.
Was he part of the confined?
I am yet to establish that, but I would think he wasn't. But it's the fact that I can establish sooner rather than later. But at the moment I'm sitting on your radio, I don't think Kangombe was one of those who were confined. He was a bit critical about the process, even before. We all had agreed this is wrong, and this is why for us, on principle, we divorced ourselves from it. But in there, he tried to put up a fight. But you could see the heckling, you could see the fights that they had, and some of the issues that he had raised, they had already adopted them, because, see, they are also trying to sanitize Bill 7. So when you use your enemy to help you achieve your score, sometimes it's better for you to just use your enemy. So Kangombe may have been thinking, yeah, I'm arguing, I'm putting my points up, but what he was simply doing was helping them sanitize the process. Now, they went ahead and voted. Okay, what still remains a fact which cannot be deleted is that judgment of the Constitutional Court is still standing, that Bill number 7 is a nullity. Now, or the process that brought about...
But at this point, can it still be challenged?
Here's a scenario.
Legally.
The process that brought about Bill number 7 is a nullity. There's a matter before the court right now, to try and establish, if what is happening in Parliament is correct. I think Laz has taken the matter back to court. The question really is, which Zambians need to understand. Can you proceed with a process, or with a bill, rather, that resulted from a process that itself was condemned as a nullity? In fact, even the UPND government is aware of this. You see, the UPND government first is very daring, okay? But secondly, I think it thinks Zambians are people of low intellect and low esteem, that they don't care, what is happening to a process that changes the flair of their governance system. But they're aware of it. If you're not aware, the Attorney General has gone back to court, okay, going to ask the court to vacate the decision they made in Munia Zulu and the Attorney General. Now, if you believe that what you're doing in Parliament is correct, why have you gone back to court to go and ask the same court that made a decision that condemned your process and that they should vacate it? It's simply because you know that what you're doing is actually wrong.
So when you say they should vacate it, what do you mean?
Vacate it means they should change. They should say our decision that the process that brought about Bill 7 was wrong. Therefore, we are changing. We are vacating it. It doesn't exist anymore. In other words, in simple terms, the Attorney General wants them to go and delete Munia Zulu and the Attorney General. Okay, as at now. Okay, That raises questions for anybody who's inquisitive in Zambia, or anybody who just is a governance expert or a person interested in governance. How can the Attorney General, who is the drafter of Bill 7 and who thinks that Bill 7 is rightly in Parliament, how can he go back to court himself to go and say to the court, oh, no, can you please change your views on Munia Zulu and Mkandila versus the Attorney General, because we want to go ahead with Bill 7. If they were a decent government, they should have given chance to the court to examine itself. Courts do vacate decisions before. They've changed decisions that they've made before. But you need to convince them. But see, you can't also mock the courts by going to court to go and apply that I would like you to change the decision that you made in Munia Zulu versus the Attorney General, and still go ahead with the process before the court is able to examine your before it. It's a mockery to everybody. But also, like I said myself, it is like they're toiling with governance. You see, the UPND is renowned for one thing. UPND thinks you can play around with governing people. They think that, there's no distinction between governing or kuchatera, there must be distinctions. Governance is a science. There are processes that you always have to put in place. The reason why we've got these processes, believe it or not, Zach, is because future generations are going to ask questions on how they are going to have to deal with issues that will come to the fore at that time. This is not the last time we're amending the Constitution. A generation that will come maybe in 2064 in this country might want, for a reason that will have arisen at that time, to see if they can consider amending the Constitution. Now, in constitution making, and especially in legal systems, we have what is called judicial precedent. You always depend on what those who were there before you tried to do to solve a problem that has come and looks quite similar or akin to what had done before. Now, in trying to rely on what we are doing right now, I shudder to think what our grandchildren or great-grandchildren will be doing in 2064. Was Mr. Kabesha correct? Okay? Was the Constitutional Court correct? Was Honorable George Chisanga correct to abscond Parliament when they were considering this bill? Okay, was the Speaker of the National Assembly correct to guide the debate on Bill 7 in a manner that she guided it, including culminating in a dance, in a victory dance on the floor of Parliament after Bill 7 had gone, given this controversy surrounding Bill 7? The reason why we always want to aspire to do what seems right at any given time is that sort of that we can make a reference point for future generations, but also so that even us can be judged correctly by posterity. Posterity is the greatest judge. I am very convinced that even Kabesha Muliro, the Attorney General, State Council, he's aware that what we're doing here is incorrect. It is just that it's convenient to His Excellency the Republican President, because this Bill 7 is a document of Community House, Mr. Zach. It's not a community of anybody else. It's not even those MPs for in that house are watching. We sat somewhere and we were interrogating, what are they doing before we went to court? None of the MPs for the UPND could argue convincingly why they were voting yes for Bill 7. None of them. They're just been whipped into place and told, come to Parliament, sit here and vote. And they voted.
My question is, when it comes to challenging Bill 7, is there room? And what happens after the president signs into law?
There's currently room. In fact, there's a matter that was in court yesterday. I just didn't know what the ultimate outcome was because I had to rush back to Parliament to go and speak to our colleagues, after the voting took place. But somebody has challenged the process, including Bill 7. I was in court with Linda Kasonde and even the Attorney General yesterday, where they're raising issues. Of course, they were dealing with first preliminary issues. Right. But I think the question that seems to have arisen now is, given the fact that the technical committee prepared a draft, made it available to the government, and the government rejected that draft and fell back on Bill 7. Yeah. Is that the correct procedure? That question is being asked. But there's still room to challenge that bill before it become. There was room. But now the only thing that is remaining is presidential assent.
Yes, and when that is done, whilst we have the matter in court.
That's why in common parlance, when you have taken a matter to court, it is always decent to suspend what you are doing and allow the due process of the law to take place and come to an end. Under the UPND, the due process of the law is not an imperative. In fact, complying with the law, insofar as the UPND is concerned, is not an imperative. It's a convenience. If it is inconvenience for them to comply with the law, they will not do it. I don't know which stakeholders the UPND given assurances too that this bill will pass before the end of the year, and that was the target they were focusing on. This is the fastest law we have amended in this country from the time of independence. This one. This is the fastest constitutional amendment process we have undertaken in this country since independence. And what should shock you right now is that usually when you amend a law as important as a constitution, there must be jubilation by the subjects of the law. They must go to the streets and celebrate. Oh, we have amended, we have now changed. Have you seen how quiet the population is after Bill 7 passed its third reading? The only people who are excited are UPND members of parliament, a few UPND members, because I've spoken to UPND members myself. Some of them are astounded. They are confused that they can be dragged into this process of amendment. You know, you haven't seen anybody marching with placards to go to community house or state house to go and say, oh yeah, thank you very much, Mr. President, you have delivered. The way Act Number 2, for instance, was delivered. Act Number 2 was delivered with pomp and excitement. Even the UPND itself agreed with the amendment of the law to come up with Act Number 2 because they participated in the process up to the end. They even debated with us on the floor of the House in Parliament. But this one, it tells you the mood of the nation, but it also tells you a message if you are a leader. You need now to examine whether you are with the people or you're not with the people, because the subjects of the Constitution, they have not gone out to that street to go and celebrate. Everybody is angry with what happened. Phone calls that we're receiving are just of nothing else but anger. Especially, and this is a question I wanted to ask earlier on, I just forgot. We need to be able to ask the UPND, is this the way you are going to be directing or driving a process of amending constitutions? That you can steal people and hide them somewhere, you know, and bring them, you know, like sheep going to slaughter on the day to go and amend the constitution, put them in the chamber and not allow them to exercise their free will and free mind and have them just, you know, press yes on the vote without debating. Is that how we're going to be doing it? And if you've seen, this is just side B of the record of the UPND. When we were dealing with Bill 10, they didn't want their members of parliament to participate or vote for Bill 10. You saw what they did? Again, they were kidnapped. They were kept out of circulation until Bill 10 fell on the floor of the House. Then they got them dancing and enjoying themselves. Now the flip side is what has happened. And I feel sorry for these MPs. At least those who were there when we were dealing with Bill 10, once the Bill 10 had collapsed on the floor of the House, you saw, Hungry Lion being flashed all over the place and the records dancing. You saw those ones who were dancing. At least they had some semblance of a celebration that they had won something or they had collapsed something that should have, according to the assessment, changed, the flow of the country. Now, what is very surprising about this is that what is contained in Bill 7 is worse than what was contained in Bill 10. So that some of what was in Bill 10 is actually in Bill 7. Now, the same guys who were dancing in the Mamwankole when Bill 10 collapsed are the same ones who came to that house to go and support Bill 7. So why have they done it? Because it is theirs. If it is ever neighbor PF, you need to collapse it. And like I said, I wish we could have some. I wish these even the PF and independent MPs who supported Bill 7, I wish they could just be given maybe just chips without chicken, from Hungry Land, just to also tell them to thank them the way they thanked their colleagues when they collapsed Bill 10.
Now, my guest this morning on the Tuesday edition of The Burning Issue is Honorable George Chisanga, Member of Parliament for Lukashya Constituency and a lawyer by profession, and also the chairperson of the Legal Committee of the Patriotic Front. I would like us to also look at the content. Now, this bill has passed, right? And we must now begin to accept to live of this being the law. Where do you think and where are you most worried now that we are where we are? Going forward, this will become part of our lives.
Well, there are a number of things I think that took place. Of course, he needed to sugarcoat it. They needed to window dress it to show that they are being objective. So some clauses, I think, were dropped. But the ones that have remained that give me the greatest worry. Firstly, it is one that had to do with sending back members of parliament to the council assemblies. I'm now going back to Lukashya.
You'll be sitting in the council meetings.
As much as I say yes. That basically breaks the system of oversight and the separation of powers, because I'm a legislature. That system there is part of the local authorities, which we provide oversight for in Parliament, because local authorities come to Parliament to submit their reports. They appear before some committees of Parliament and we debate their reports on the floor of the House.
That's right.
Now you're sending me back to go and sit there. Firstly, it's a costly process, which is unnecessary. It's supposed to be avoidable. Secondly, you're just lumbering me with additional work. Already I have CDF to oversee. Already I have several other issues to do with the constituency, especially sitting in the House to provide, checks and balances to the government and also oversight of government transactions. Then you send me there, you add to it, but you also add the cost of running local authorities. Okay, but the most controversial ones are now a 5-year, a civil servant who has served in civil service for 5 years is eligible to be appointed as secretary to the cabinet. When I was discussing this to build up, I was saying, civil service it works like an octopus. It's the most complex administrative institution anybody can ever dare to think about. There was a reason why a 10 years experience was prescribed in the previous constitution and the previous laws. But also, most importantly, within the Commonwealth, the trend is to have seasoned and experienced civil servants to manage the affairs of civil service. I remember an incident that happened when you moved from UNIP to MMD. There was chaos in the civil service because all the seasoned civil servants were pushed out, as happens usually when you change government, and they brought in mainly novices that failed to manage civil service. That bureaucracy was almost beginning to collapse. In fact, the collapse that took place at the time the MMDK took power is being felt even today. If you go to the Ministry of Lands, if you go to Transport, if you go to local authority, things like liquor licensing tribunals don't sit anymore. Things like, rates and valuation tribunals don't, because we collapsed it. Because why? We pushed up people that were experienced. What I remember happened under Chiluba is that they actually had to go and bring back the person who they had retired as secretary to cabinet, brought him back and said, please help us clean up. And they had to clean up. Now, that's how important experience is. But for the UPND, they actually think that bureaucracy is an inhibition. If you hear the president, most of the times he complains about the slowness in civil service.
Yeah.
You see, and there are ways in which you can make civil service work better than changing the secretary to cabinet by removing people who are qualified and putting people that are less qualified. Can you imagine now a 5-year civil servant who may, because he's a relative of Honorable Jack, Honorable Zach, you persuade somebody or the appointing authority, please make him secretary to cabinet. Who is going to be giving leverage to that person or reverence to that person or respect to that person? We are going to further collapse civil service. What I'm thinking we should have done with civil service is manage it away from the constitutional dictate. Just do a reform of civil service, like Edgar Lungu had tried to do towards the end of his tenure. We tried to bring into civil service professionalism, but of course recognizing the importance of qualifications and experience. But what the UPND has tried to do with this one, they're literally going to make civil service collapse even further from where it has been currently. And this is all been done to respond to the frustration that the president has and a few other connected people have on how civil service is functioning, because you always have to wait for the secretary to cabinet who's qualified to give you guidance. The secretary to cabinet, by the way, is a chief advisor for civil service matters to the president and to cabinet. So you can't afford to give such a job to somebody who only has 5 years experience. Look at this. The bank governor requires 10 years experience. The secretary of treasury, who to an extent also reports to the secretary to cabinet, requires 10 years. The auditor general requires 10 years. Every sitting judge, in the High Court requires 10 years. Yeah. The attorney general and solicitor general requires 10 years. Isn't this just consistent? Isn't this just because there's some kind of reason that help you to be effective in managing civil service? But then you go to the topmost position of civil service and collapse the qualification requirements. Okay? The controversial one, frankly speaking, and this is a very painful thing for us to go through right now. I really hope that now Zambians, you see, those of you who had doubts about why Bill 7 was being insisted upon, I am going to beg you, pay attention to what is going to happen to delimitation. I have failed to sleep from yesterday up to now. In fact, I failed to sleep the day I saw Sishua unleash a delimitation report of 2019, which showed how the Patriotic Front at that time had attempted to, distribute constituencies. Zambians were crying that you can't ask us to participate in Bill number 7 without showing us what is going to be contained in the delimitation report. The UPND was quiet about that. We were pushing the agenda just to amend the constitution, forget the delimitation report. We were going, but in the one of the major objectives of the of Bill number 7 is to implement delimitation, or to actualize the delimitation of the constituencies. So you are asking us to amend the law without showing us which constituencies are going to arise in the amendment. They have a duty of disclosure of the number of new constituencies that are going to be created and where they are located in the delimitation report. That was not made available. It is only going to be made available now that we have passed. I question.
Do you think it could be doctored?
Here's what the answer to that is this. I feared when I saw Sishua distribute that
2019 bill.
2019 report, because first I thought it was this one for this year. I told myself, so who leaked it to the public? How come it's in the hands of a member of the public? But when I went and read it, I saw it's a 2019 delimitation report. Then I
but that too has not been published.
Then I sighed with relief. Okay, it was published, I think, alongside the Bill 10, which collapsed. Then I sighed with relief. I said, okay, so here is what is important. What now Zambians have is an opportunity to compare the one that Sishua has made available with the one that the ECZ through Mr. Kasaro has given to the president. Because remember, just when before Sishua's delimitation report became public, there was controversy about where the delimitation report is. Okay, Honorable Chipoka Mulenga, said, look, insofar as we're concerned, whoever wants it can go to ECZ. We'll find it. Honorable Mlambo Haimbe echoed what Honorable Chipoka said. If you want to find the delimitation report, please just go to ECZ. For us, we are cabinet, we have nothing to do with this. Please, the technocrat can go and share it with you. Okay? When Kasaro had an opportunity to appear before the Select Committee to scrutinize Bill 7, he made a disclosure. And I can tell you, he made those disclosures under very difficult circumstances, because he was compelled by a question that came from one of the members of the committee. And then he made this disclosure that we actually gave the report to the executive, meaning the president. And he even said, insofar as ECZ is concerned, once the report is handed over to the president, which is correct, we are resting. We have nothing to do with the delimitation report. So the ones who have actually been hiding this report are the government, the UPND government. And the reasons are now going to become clearer, because once they make this report available, and that's why I thanked Sishua before for releasing that, because Zambians now have a basis for discussion. They will be looking at two delimitation reports, the 2019 one and the one that is now going to be the latest.
Well, Shishua's may not be official, and government may say that this is what you take as official. So,
as I'm speaking to you now, nobody has disputed Shishua's document. Okay, but also people that have seen the actual document have said that was an official document. It's got signatures, or it bears signatures of the authorized officials of the ECZ at the time.
Okay.
Okay. So, but the point, Zach, which you should not escape, is that now an opportunity is going to arise for Zambians to do. God has answered one of the very controversial reasons why some of us were refusing.
So you're not against delimitation. Is that what you're saying? You are not against delimitation, but what you are not comfortable with is the fact that it hasn't been published, and we don't know which ones will be delimitated.
The manner in which the program has been managed has raised so much controversy, not only to us as MPs, but several other stakeholders. Amongst the main controversies is the absence of a delimitation report. Okay, now it is going to be made available. If you've seen already, this sector has been soiled. If I was the president, I would have made sure I released the delimitation report at the very moment I spoke about amendment to the Constitution, so that you put it beyond doubt, what you're about to achieve. Right now, people are accusing this government of wanting to achieve what is called, a lopsided political system, where the constituencies that are going to be delimited are only those that belong to, in traditional terms, they are strongholds. Okay? What happens? Zambians have already interpreted this, that they want to give themselves an unfair advantage. But for me, I even took this argument further. In my political science and in my interactions with those who've studied political science, one thing that had become a tradition in this country was to make the presidency regional neutral. They implemented a principle of regional neutrality. That principle means that it doesn't matter under the current constitutional setting or under the current political setting. It doesn't matter which region of the country you come from. You just need to convince Zambians that you are capable, they will vote for you as president. Some people have now started arguing, and this is where the Sishua debate comes in, that these guys now want to tilt the balance in favor of one region or a certain region of this country, so that if there will be more constituencies in those regions, then it's more easier to get it to become electable as a president if you come from that region, because the tendency is to vote for Mwanawapakomo. You know, like Wako Nwako, you guys at the term code Wako Nwako or Kumao, Mozi Kumao. All those things now might become part of our political process. It's an argument, and somebody has to dispute it, but also for the government, they have to dispute it by laying down the delimitation report. But what I've argued is this: if the delimitation report that is going to be produced now, pursuant to Bill number 7 of 2025, is going to be different from the one that was produced in 2019, and this will be so marked that the one in 2019 will look equitable, the distribution of constituencies around the country, than the one that is going to be produced now, then somebody can convince themselves that we have departed from the principle of regional unity when it comes to forming government, electing a president, and having
have the right to dispute a report if what they submitted and what has been published are different? Would you want to challenge that they should?
I think for the sake of transparency, ECZ should be able to, stamina up and come and say what we have seen from government and what we gave them are two different things. Why? Because the institution that went around and carried out this delimitation is ECZ. They are the ones who know the reasons why specific constituencies were placed in the report. So if what is going to become available will have marked differences between what they have produced and what will be made available by cabinet, frankly speaking, and for the sake of being patriots and nationalists, you should be able to come and say, no, I think this was wrong. Just like the Technical Committee did. Look, the Technical Committee was appointed with a specific purpose to sanitize Bill 7. You see, I was paying gratitude to Justice Mushavati, who chaired that committee, because whoever was appointing them, or rather, not even whoever, it's actually the president. Let me not be sarcastic. I respect this president very much, and I think he knows it. I have said it so many times.
Right.
The president, when making these appointments, I am very convinced he had a certain mindset. He had certain expectations of how they were going to work and what they're going to produce, because he complied with the provisions of the Constitution that give him power to appoint people to do work for him, even when a technical committee is supposed to be, strictly speaking, appointed to do work for the public, because constitutional making is not a presidential program. It's a program for the people of them, but he appointed them to do it for him. And when they produced that report, he must have been very and confounded, because he has departed from what was contained in the report. But for me, I say that's what it means to be a patriot and to be a Zambian. Because you see, the president only appointed this committee. He didn't go with them where they went. This committee went and interacted with the public out there, and the public gave them their views about what they would like to see go into Bill 7. So when they authored the report, they were authoring a report out of the submissions that were made to them by the people. So for me, I paid homage, and I paid, I saluted the whole technical committee for choosing to be Zambian, for choosing to do what is right as opposed to what is convenient. But you see, I just was angry, because after the government refused to accept their report, I expected matters to have settled there, because they had done their report, they had appended their signatures to the report. They were, in legal terms, they were functus officio, meaning they had done their work with finality. But government was able to do what I felt was... What would cause
government rejecting a report as that of Mushavati?
Well, they have to give reasons why. We haven't been given reasons why. But the only reason I would...
Something that did not favor
the only reason
the government.
Let me say this. when the government chooses to reject the submit or the report of a technical committee or any commission of inquiry, it is because they would have done an assessment themselves as government that this would not be, to accept this would not be in the interest of the Zambian people. They're that liberty. But see, once they do that, it settles there. My assessment now, logically speaking, if they want that inquisition to produce results, they have to start it all over again. But see, what they can't do is they can't say, we reject this to fall back on Bill 7. That, again, for me, is a constitutional infraction. Okay, but like I said, UPND had a target. Their target was to pass this bill come what may. If it means stealing MPs from PF and hiding them somewhere, that's it.
So the setup of the technical committee, to you, in short, it's cosmetic. It was cosmetic.
It was a highly cosmetic process. And they did...
Just please the constitutional court, is that what you're saying?
Yes, but also with the thinking that they were going to, this technical committee was going to toil the land. Because remember, they were given terms of reference which were similar to Bill 7.
Yeah.
So it was a structured movement they were making. So these guys fell off the file and did what was right. And for me, I take my hat off to them, quite frankly. That's what Zambians must do. You should always save the public without fear or favor, because at the end of the day, everything that is in the Constitution, it vests in the people. So now you ask me a question that, so for me, the highest controversy in this is really the delimitation report. And I'm asking Zambians to be interrogative. Please follow what is happening, because this is likely to change the composition or the country as we have known it from 1964, because now it's going to be a very different country. Until, of course, we do another constitutional amendment.
Yeah. So you've cited you've cited two so far that you are not comfortable with.
I think for me those are the most controversial ones I can think of, because I haven't even read the report in detail. I was following on what was going on in Parliament. I was hearing the chairman of the committee suggesting to the government what was being dropped and what was going. I told you about the by-elections. After somebody dies in office or somebody is removed. There was a thinking that the party in power must be the one that should nominate who should go to replace us. It's for me, it's counterproductive. They also, I think, have removed the limitation of the terms of the mayoral position. Mayors would be elected, for only 2 terms, not beyond. So a mayor's time was as capped as that of a president. For reasons that I think they haven't explained in detail, but just to make it consistent with the members of parliament, they've said, please remove the mayor. On the street, word is going out. People are thinking, what next? Okay? Because in this arrangement that they are now going to bring in mixed member representation, which they call proportional representation. I think that for me, first, there's a tautology with this. We run a direct democracy here. We don't run one like one in South Africa, where a party is the one that contains and then it chooses who to put in parliament. Here we are elected directly to parliament, but they've now introduced a system where a party that polls will use a percentage of his numbers in parliament to determine how many people they're going to appoint to bring to parliament without an election. The worry that we've had with that is that there are so many people that are going to end up in that parliament being directly elected. So we are watering down the right of Zambians to elect persons of their choices. But also we are turning political parties into clubs, or into for lack of a better term, we are turning political parties into mafia institutions. Because now it is what does the most powerful person in the political party say? Previously, they had, for lack of a better term, they had lied to the women, for instance, that the NGOCC or some other women grouping is the one that is going to be bringing women to parliament through that process of proportional representation. That the youths, whatever youth movement you've got somewhere, is one that's going to be bringing these people to whatever. And the Zambia Association of Persons with Disabilities are the ones who are going to bring those people to parliament. They actually had cooked that lie to the extent that, if you remember, NGOCC at first had supported Bill 7. It is when, if God wants to confuse you, put a language in your mouth. So God had put a language in the mouth of the UPND ministers, especially Cornelius Chimuto. That's the one who came to radio and fumbled to explain what this proportional representation is. But it became very clear, and we had said it before, that this is arming political parties to be bringing their loyal cadres into parliament. Because now, in this proportional representation, and this is actually the position on the ground, if, for instance, the next election, Tonse Alliance gets 59% of the vote, okay? produces a president and produces the biggest number of members of parliament in there. So the 40 number that has been earmarked for mixed member representation will now be apportioned to political parties. The Tonse Alliance will take, a percentage of 59% of that 40 will come from Tonse Alliance. So you're actually creating a very big dictatorship, in parliament, because that then also deals with, the 1/3, 2/3 majority, depending on how you force it. So you're going to have a parliament. It's better to have a parliament which is hung than have one which has got an absolute majority. Because if for instance now, okay, now when the UPND does not have an absolute majority in parliament, they can create one by hijacking members of parliament on the opposite side and keeping them someone, bring them in. If they can do it now without a constitutional dictate, can you imagine what is going to happen if now this, and it has become law, if now it becomes a scenario where another political party wins and begins to behave the same way UPND is behaving, you will have lost it on democracy. But there's somebody who gave an example of what might likely happen. There's a story in South Africa where Zuma, through their political party, they had put in parliament through this proportional representation. It coincidentally so happened that his daughter is the one who was nominated and put in parliament. Okay, now this lady has some criminal case going on against her. Yeah. And the thinking of the party was that, look, we don't want this to brush on the party. Can we withdraw her? Can we nominate somebody else to parliament? Guess who's been nominated? Zuma's other daughter. So it's even now possible for Mr. Chisanga, who's got so many daughters when I become the leader of a party or even the president, to be behaving the same way that Zuma's party has behaved. Like, remove my first daughter because she's having some challenges. Please go and bring back my Kasuli and make her the next member of parliament. So it becomes a family affair. And these things are very real. I mean, follow the story, of Raila Odinga in Kenya. The daughter to Raila, belongs to the party that the father used to manage. She was even the bodyguard for the father. What position she was given? East Africa has got an assembly, like a parliament, East African parliament. This Winnie daughter is the one who Raila's party had nominated to send to East African parliament. Now that the father has died, a vacancy has occurred in the Legislative Assembly in Kenya. I'm very convinced that she's probably the one who's going to be. So for them, it has become part of a political culture which is acceptable. I don't know whether this is something that we're prepared to accept if we put in this mixed member representation that we are so much talking about. But the most important, even to do this, the UPND was basically duping the public. They wanted to do it to create an added advantage to increase the number of people that they send to parliament without going through the elective process. Because at the end of the day, what they want is a 2/3 majority of parliament, so they can be controlling everything from executive to parliament. And then, of course, you have the judiciary. I don't want to give opinions about the judiciary, which I've said so many times.
But then we just have a few minutes before we close. Yes. Unfortunately, we will not be able to take phone calls because we started late. But I'll give you one interesting comment on Facebook. Which is from Sikoli Mungole, who says, Zach, good morning. Ask Lawyer Chisanga, during Bill 10, was the delimitation report published to the public by the government then?
It was published. How has the issue gotten it? It was part of the discussion process. In fact, in there, even the constituencies, if you saw the report that Sishu made available, there was even numbers of constituencies that are going to. In Northern Province, there were so many, they're going to create so many. Southern Province, there were so many, they're going to create so many. That's what people were expecting is supposed to happen even with Bill 7.
Let me take you to quickly, because we don't have time.
Yes.
We have a by-election coming up, yes. Chawama, and this is what the Patriotic Front has held for a long time, and this constituency is controversial now. We are coming from the controversial Bill 7. Now we are getting into, actually nominations are ongoing right now as we speak.
Yes.
The Patriot Front is not participating in this by-election. Correct me if I'm wrong. What is the status quo?
Firstly, I just want to express sadness at how my colleague, Mrs. Lungu Mwansa, lost this position. Tasila is one of the most hardworking members of parliament we had in that parliament. Even she was a new entrant, but she had experience, coming out of being a councillor, in Chawama itself and running Chawama constituency as effectively as a young lady could possibly have done that. The circumstances losing Tasila losing that position are very unfortunate, but it's spilled milk, we can't cry over it.
Right.
The PF is not participating in this election as PF because we continue to be beleaguered by the problems that were created as per the UPND, where now, one individual has got the papers, Registrar of Society has got certain details, and our preferred leader, our appointed and recognized leaders are not even able to be the ones to indicate to us who they're going to sponsor. But, of course, with our partners in Tonse Alliance, we have identified a political party that is going to be a flag bearer. And yesterday they picked a candidate. I think the nomination is taking place right now. We were very involved in it because me and Honorable Brian Mundubile and the other members from Parliament were at court yesterday following up two matters. The first matter we were following up was the very matter of Bill 7 in the Constitutional Court. Later we were following up the matter of Tasila Lungu herself. You remember she's taken this matter to the High Court by judicial review because we still believe sincerely up to now that the Speaker was wrong in making that declaration of declaring the seat vacant. But because we don't want to be caught napping, we spoke to our colleagues in Tonse Alliance and we were graciously allowed as Patriotic Front to nominate which political party we're going to utilize and which individual we're going to sponsor. We have got a very formidable member, I think Mr. Nundu. I need to confirm because I wasn't participating in the election, but I'm thinking.
But which vehicle are you using?
We're going to use Forum for Development and Democracy.
FDD. So FDD is definitely PF representation.
FDD is part of the Tonse Alliance, and it is one that has been preferred. If you remember, we had picked on a party called the Congress Party, which, with the same kind of machinations, etc., we seem to have lost ties with that political party. Leadership is still engaging to try and see if we can find common ground to continue, because that party is sitting with our member of parliament, sitting with a councillor. So we still consider them as part of Tonse Alliance, but alliances are not things you can force on people. So we thought that the more mature, Forum for Democracy and Development can come on board, and they've been on board for a long time. And I must let you know that even before President Lungu and President Nawakwi passed, we were in top gear trying to get into engagements with them to consolidate the Tonse leadership through the FDD and any other political parties that are in there. So they are our partners, and we are very convinced that we will be able to sell the candidate properly, and if we are allowed to run a free and fair election, we're very sure we can take the.
And you've taken this stance of participating in the by-election through FDD, and then you have a case against the Speaker. Of course, Tasila has taken the matter to court, but then, what would you try and achieve? Because I think that the big we want to get out of it is to stop a by-election from happening, because then you have an aggrieved member of parliament. So what are you trying to achieve having that and while at the same time participate in the by-election?
I think we seek justice. If you've seen what we've done, what we have suffered at the hands of the Speaker in the last 5 years, it's a telling story. We've lost seats in circumstances where it was difficult to lose them. When they noticed that through those declarations of the Speaker, we were challenging most of them in court and people were being returned to their seats, they chose the route of criminal justice, and a number of our MPs lost their seats through convictions, etc., etc. But this one, we think that I think the Speaker was most unfair, and in the pursuit of that, Mrs. Monsa must just pursue this to establish, if not to get the seat back, then at least to make it. You remember there was one case for Honorable Chimbakambili that was decided even after an election had taken place. Yes. What happened to him was wrong. So we have a reference point that is being utilized when you deal with the matter where somebody falls in the same place where Honorable Chimbakambili had fallen into. So my thing is that even with Honorable Tasila Lungu Mwansa, if peradventure this happens where after we've done the election, which I know we're going to win, we can still make a point, because in any case, here we are moving as FDD, in there we are moving as Tasila representing the Patriotic Front as the owner of a seat.
So if you FDD, well, as an alliance, Tonse alliance, if you win that election, and the court decides Tasila gets it back,
that's when we're going to reach the bridge, and I think it won't be our problem. If you think it will be a problem for Parliament, it will be a problem for ECZ, it will be a problem for government. It will actually not be our problem. For us, we We think participating credible. People in Chawama are crying out for good representation. UPND has been campaigning in Chawama from the time that President Edgar Lungu died. You've heard some of the invectives that have come out of the so-called candidates who wanted to stand on the UPND, insulting Tasira, insulting the dead body, asking issues, let's bury this person, let's do that, you are a thief, you're not going to come here, we know this seat is vacant. They've literally been on a war cry for all this time, but the people of Chawama that we've been canvassing and speaking to have made it very clear they would like to get representation at Parliament, and they would like to get it through somebody who will have the support of the structures that are within the Tonse Alliance.
So for Tasila's sake, and I know this will be Tasila's sake, well, are we going to see Brian Mundubile, Given Lubinda, Makebe Zulu, name them, all these presidential candidates on one stage in Chawama?
People of Chawama get it from me. I'm one of the leaders in the Tonse Alliance leadership platform. All our leaders, President Given Lubinda, aspiring candidate Brown Mundubile, aspiring candidate Makebe Zulu, every other credible leader of the Patriotic Front, and other members of the Tonse Alliance, we will be in canvassing votes and spearheading the campaign for our candidate under the FDD flagship. That's our assurance.
Honorable Judge Chisanga, Member of Parliament for Lukashya Constituency and lawyer by profession, and the chairperson for the Committee of the Patriotic Front, I would like to thank you very much for coming today, unless you have under a minute a closing remark.
Thank you, Zach. Always a pleasure to be here, but today we are discussing a very emotional topic of Bill 7. For me, it is just to ask the Zambians to be inquisitive, be interrogative. We have done something that is terribly and fundamentally wrong. I know I will live long enough to come and see a challenge that will be made to what we have done with Bill 7 now. And I hope that at that time, or at any time for that matter, we're going to find a judicial institution that is capable and intelligent enough and independent enough and accountable enough to try and rectify this mistake we've made. Because we're now going to be living with a fractured democracy because of what we've done with Bill 7. It is wrong in the way it was conceived. It is wrong in the way it's been implemented. It is wrong because we have defied the order of the Constitutional Court to say we shouldn't do it, and we've gone ahead to do it. I'm looking for a day when this thing is going to be reversed. But in the meantime, Zambians, your eyes are on delimitation. Zambians, your eyes are on all those clauses that talk about new constituencies coming, Secretary to Cabinet qualification, member of parliament returning to council when there's absolutely no need for that to happen. But this is the country we're living in. We have destroyed our own country. We have a responsibility to put it up back together. For us as part of Tonse Alliance, we are willing to take the bull by its horn because we only have one Zambia. And we have a responsibility to leave a legacy to those who are going to be citizens of this country after we're long gone and forgotten about. Thank you very much.
Thank you. Well, that was our guest for today on our